Welcome to the program Law and Order. Ladies and gentlemen, as you know, the Law and Order program, we are giving you a scope of legal scenarios, giving you solutions and giving you the particular advices with the distinguished personalities present here on the studios in order to prevent yourselves getting on trouble. And we discussed from our previous episode about minor offences and certain scopes with regard to that. And today, from our today's episode, we are going to focus about certain dispute managements and the local authorities, police and even filing court cases. So to do the honors with us, we do have Mr. Jagatha Benayaka, attorney at law, a thorough gentleman in the field of criminal law. Thank you very much, sir, for taking part in this program.
Thank you for kind words.
Right. Okay. So, ladies and gentlemen, we are going to start off today's program, and sir, let's explain. We explained actually what minor offences are, and when it comes to certain disputes arose in sometimes villages, sometimes in a small scale, there might be certain disputes. So let us explain what certain those disputes are.
Yeah, dispute resolution. I am expressing my ideas as a criminal lawyer.
Yes.
So my scope will be limited to criminal areas. Dispute resolution in criminal areas can be done not only, and people think that you have to go to courts, you have to go to the police stations, and there are a lot of rigmaroles that you have to go through. But not only that, you can also complain to other places. Even a Grama Sevaka can take down. He is described as a peace officer in the criminal procedure code, and peace officers can even arrest people.
Right.
If an offence is committed in front of Grama Sevaka, he can arrest the offender.
Right. That means he has certain powers like
yes,
a police officer.
Yes, he's a peace officer. He has a prime duty of. He has to see that at least in his presence, the peace is not breached.
Right.
Right. So wherever it happens, he has the authority under Section 32, if I remember right, of the criminal procedure code. He can arrest, restrain people from going into atrocities that would breach peace in his area. There are alternative dispute resolution mechanisms in the country. One is mediation board.
Right.
In fact, even a police case can be directed to mediation board. A complaint lodged with the police can directly direct it to the mediation board, and mediation board is also a very good place for people to present their cases without getting representation from a lawyer, which will be, people will be at ease, because most probably the mediation board is presided by a person who is known to the area, who is supposed to be a person from the area. So there is no such awe or no such fear that the man would feel like in a court or like in a police office, police station. So it is always best to go there. And I know it has gone into such extent, like for example, non-paying a telephone bill. Telephone companies lodge the complaints at mediation boards.
Not moving to the courts.
Yeah, it is not about punishing people, hearing case, punishing people. It's about settling a dispute without going into the court procedure. Yeah.
For example, confining those minor dispute to a certain village or certain thing, the villagers or a small group of people, they are to a certain dispute and they might quarrel or they are seeking for a solution. The best thing that you would advise not to run to the police, but instead the peace officer, the Grama Sevaka responsible for that locality, is being there to present those things.
Even Grama Sevaka can take down their statements. Yes, there's a provision like that. And they can, if it is something that should be handled by the police, the Grama Sevaka will direct them to the police. Sometimes most of the disputes that the villagers come up with is related to their property.
Yes.
There might be a problem of fence, there might be a problem of a tree, or
might be the access to the land.
Yes, access to the land, the roadway. such disputes can be easily settled at that level without going into court procedure.
Court procedure. And apart from that, Grama Sevaka, like if he is the most fitting person as the peace officer responsible for that area, he will direct to the police.
Yes.
And rather, for example, sir, when it comes to a certain scenario, my property is there, and to beyond my property limits, there is a potential danger from a tree that is not belonging to my property but the adjacent property. I don't have legal rights to remove that. It might be a theft moving that property, as we discussed in the previous episode.
Definitely.
And how can we deal with it? It's directly running to the police or to the Grama Sevaka or to any local authority there?
Best place is the local authority, which is maybe the provincial council or maybe the municipal council. You can lodge the complaint at
complaint as in we are going to write?
In writing, most probably in writing.
Right.
Because oral complaint can be made, but I suppose it is always better that you leave a record of your complaint.
So best thing is writing.
Yes.
So we suppose that we gave it in writing to that particular responsible authority. It might be the chairperson or any other responsible authority. And how they look into that?
They will come and inspect the scene
scenario.
They know the area. It's
Right.
it is their bread and butter, so to speak. You see, so they will come and see what is the situation. So they can always remove whatever is endangered in the human occupation, whatever is endangered in the human life. They can always remove it. May be a tree, it may be a wall, it may be even a house. If it is so dilapidated that it's going to collapse on somebody else's house, then they have the right to remove it.
Might be a proper fence to protect.
Yes.
Right.
Yes.
So when it comes to that sort of an inspection, they might advise both the parties, this is the scenario and you should definitely cut this or put these branches down or any solution. But if the other party is not adhering to those instructions, and if it is yet in potential situation, and for example with a certain natural thing, a wind or a landslide, that tree falls to my property, will that presumption as in like I have written to the particular authority prior, will that be effective?
Very effective, because I have not slept over my rights. I have immediately informed the proper authorities to remove the danger, and while it was disputed and not being removed, if it has fallen on my property and damaging me or my life or my properties, then I certainly have a good case in court.
Good case in court. As you said, like not sleeping on the rights, because one judgment they particularly deliver. If we have rights, we should become active and we should come forward, because if we think that we have rights and law will protect us, they will not. Even like when it comes to a prescription or something, like my property is being used by someone else, but I'm not taking any action. When it comes to claiming the ownership, prescription right can be adjusted. But in such a scenario, can we inform the local authority he is like residing or he is using my property without my consent, so I'm just advising him to not to use, and later on if the dispute is not arisen, can that be a particular point?
I think we are moving into area of what you normally know as 66 matter.
Right.
You know, if somebody is eroding into my rights of a land or rights of a immobile property, I can always lodge a complaint at the police station. It is the police station. I have to do it, saying that he is blocking my way, or he is using my he has trespassed into my property, and he is staying in my property, and he is building up in my property, or something like that. Then always within 1 month of the breach, I'll have to lodge a complaint to the police. If the police is not taking steps, I can directly go to the court
Right.
under section 66 of the primary courts procedure.
That's why it's case 66
Yes,
cases.
that is why it is called 66
Cases.
Yeah.
So in such a scenario, like the person who is really suffering can have the advantage.
Yes, actually it is not the final decision that the court will give you. It is an interim decision where the court will look into only one aspect, that is who has breached the possession, who has lost the possession, and within 2 months period of the complaint,
Right.
and the court will restore that possession.
And restore in the
yes,
possession.
and say since it's a civil dispute, you can go to the civil court and get a resolution from that court.
That
And
court.
until then, you have to keep peace in the neighborhood.
Right. So it's like establishing the proper possession.
Actually, it is establishing the peace.
Establishing peace. Okay, so we discussed about the mediation board also, and as per your practice, we have heard that many cases from like telephone companies, the communication companies rather, they put their cases to the mediation board. So what is the role there, the mediation board?
Role is settlement.
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 Dispute
There's
settlement.
there's no punishing. There's no putting the culprits in remand. There's no thing like that. It is a settlement under peaceful circumstances. You meet two parties and you allow the two parties to present their cases without the lawyers. You can talk, and for example, if it's a payment, you can ask for an easy payment scheme or something like that, and you can come to a settlement.
No lawyers are representing the clients, and the person who is settling the dispute is a common, ordinary, well-known, a reputed, respectable citizen of the particular area. So we don't feel any like vibrant thing that we are in front of a police personnel or in front of courts or judges or what it is. And when it comes to such dispute settlements, can we claim that they don't have any legal knowledge with regard to dispute settlement? Can't we raise that thing?
It is not law, no. It is the facts that we are discussing at mediation board level. It's not law. Law does not come into that. Whether you can pay, whether there was a loan, or whether there was even a case of hurt, even a case of sometimes grievous hurt. If the victim party is willing to accept some kind of maybe the apology or some kind of a payment, and on that, if he is willing to withdraw his complaint, if he is willing to come to a settlement with the other party, that is it.
That is it.
No law comes into that. You see, it is the best way for small claims to be settled.
So ladies and gentlemen, that might be a important advice for you all, because like when it comes to dispute settlements, people run to courts or sometimes go to the police to lodge complaints. And now we discussed many issues, like we can have the peace officer. The Gram Sevaka is a responsible government servant, so you can go to him. He has even the power to take statements as Sir said, and even they can be solved in a certain manner, even if it is not being solved beyond that limit, so he'll be proceeding to the police. And even the mediation board comes into prominence place, because reputed certain institutions also move forward. It is not law, it's simply you can come to a settlement. So law is not a place to harass others, but if you have a certain issue, if you need a certain solution, you can simply proceed to such institutions and to move with and to come forward with a solution. So Grama Sevaka, the mediation board, they also do have a prominent place and a well effective mechanism in order to come into dispute settlements. So when it comes to court practice as a senior criminal lawyer, so we have to first of all select a lawyer in order to proceed our case. How can we do that?
How can I say? I don't know. What I say is, we are talking about minor offences. There are a lot of things that I have to say, but I'll say this. Of minor offences, many offences, when they are presented in court, parties always try to settle. Parties always try to settle, and parties always come forward to avoid going into a trial stage. Right? So a good lawyer is always capable of handling the needs of his clients. A criminal lawyer would always look into, if there's a settlement, look into the settlement first. I'm talking about minor offences. And then only, if that is not possible, only that he will go into a trial. If somebody is strongly convinced that he is utterly innocent, then that person is right to go into trial and come out of it scot-free. That right is undeniable.
Right.
But some people in Sri Lanka, some people see that lawyers' charges are very high. You have to go to court, and you have to lawsuits usually takes a long time to settle, conclude. Then most people in minor offense cases, even if they feel they're innocent, they are willing to plead guilty and come out of the court without serious damage to their reputation or their lives.
Right.
They are prepared to do that, not because they are guilty, but because they feel that it is much plausible for them to do so. A good lawyer would always look into such opportunities.
Right.
He can convince his client. He should be able to convince his client about the circumstance of the case.
Right. So
Whether
first is that if there is a solution we can go forward with, and if there is a particular necessity or urge to move with a trial, then only you should proceed. So simply we can't, like, if I'm dealing with a certain case, if I want to select a lawyer, there's a person called A, I'm going to him and say that you represent me. Can that be done, or is there any particular documents?
Not in criminal courts. No documents. Now proxies, they come in civil matters.
Yes.
Proxies may come in 66 matters, as we said earlier, but not in criminal cases. Our system is such that you can get hold of a professional assistance of a lawyer without any document and ask him to appear for him. Depends on the case, you know. If you are going to have a hard fighting case, if you are like I said, if you are convinced of your innocence, you can always find a good counsel, good trial lawyer, and place your case before him.
And so, like, when it comes to the ordinary clients, when it comes to cases, the innocent person or rather the pleading guilty person is a client, and when it comes to those clients or rather simply individuals, if you are seeking any legal assistance, they simply think that now lawyer is there, courts are there, we can go to lawyer and ask him to speak, and they will give a settlement the next day. Will it happen? No, obviously no. So there might be certain procedure, proper procedure. So people think that the courts are dragging cases and they're taking a lot of time, but as lawyers, like you all know, that there is a big procedure behind each and every scenario. So let's explain the general public about that particular scenario. That's why they are consuming time.
All offences are not like that. There are offences which can be commutable. There are offences which can be settled without going into trial. There are offences which are not commutable. For example, cheating. Cheating is not commutable. Cheating cannot be settled without going into trial. On such occasions, the lawyer has a role to play. The client has to give proper instructions to the lawyer if he is willing to settle. There are areas where in certain cases where you can withdraw the offense which cannot be settled, replacing it with similar offense which can be settled. For example, misappropriation. You take out cheating. My personal view is you can't do that technically, but the court practice is that in order to circumvent the trial and time consuming procedure, you can settle the matter, but lawyer has to play a role, because you have to see whether your client is getting a sentence out of it, whether your client is getting if your client is fined, whether he's a public servant, his employment has to be considered. You have to give proper instructions to the lawyer in such settlements, and lawyer has a bounded duty to explain the circumstances, explain the eventualities of a settlement, and then only in the court the lawyer can represent the client's desire to settle the case.
Yes, and so there might be a documentation part of each and every case. So can you make a comment on that?
Now, most criminal cases start with the police. You have to lodge a complaint with the police. This complaint is in court we say it's the first complaint. So the entire case based on this complaint.
Right.
So it is always better if you lodge a complaint with the police. It's always better that you give full details at the complaint itself, without going on a second occasion and recording a second statement. Without doing so, give the entire story.
Right.
It is always prudent to do so, because when there are two statements, one first complaint and then a subsequent statement, when there are discrepancies between the statements, that would not look good in your case.
All right.
You understand? So that is the most important. If it is a document, that is the most important document that has to be taken care of in a case, in a criminal case.
Right.
Thereafter, there are other documents that you can come. If there's a medical report, if there are other expert reports, they have to also come in. Then there are documental evidence in documents which has to be produced, even in the first instance when you are lodging the complaint. If it is with regard to forgery, for example, you have to say, this is the document that has been forged against me. You see, that
is the documentation part particularly.
Yes, in a criminal case is, when it comes to a criminal case, it is 80% facts. 80% fact. That's what I say. Right. About 10% law.
And that is all about the evidence that we come forward and bring evidence.
Yes.
And so, like when it comes to a police complaint, people might say that there might be errors in police complaint. So, what is the validity with regard to a court case of a police complaint, rather the police report that they are given, the statements recorded?
Yeah, statements are very important, because statements state the case at the initial stage. I have to say this, in our police, our criminal investigation stops at recording statements on most occasions. They don't go after evidence. They don't go after proper investigation. Right? There are two sides. The complainant is there. There's also the suspect. The suspect may also have a story, and our police usually is reluctant to look into the story of the suspect. Right. So the suspect will have to come to court and ask for the opportunities to present his case in court, like that. The recording of statements, and the police have to report facts to the court. Right? Not only police, even a person can go before a court with a private plaint. If the police is not taking interest in his complaint, he can always directly go to the court, and certain of it, we are talking about minor offences, so almost all minor offences can be heard in magistrate court under private plaints. You can file a private plaint, but filing a private plaint, you have to seek the assistance of a pleader. There's a lawyer. Right. Apart from that, there's no bar there's no bar preventing you from going into court direct without. surpassing the police.
Surpass the police. Right. So, ladies and gentlemen, we were discussing about minor offences, and in our previous episode, we discussed certain scenarios dealing with those offences and the legal background dealing with. And today, with this episode, we come to a certain point where we discuss the court practice and even the mediation boards, the Grama Sevaka, the local authorities, except the police and other investigation authorities, to simply dissolve or rather resolve a dispute with regard to a certain small thing without letting ourselves in courts and proceeding with the court case. But we discussed yet in court cases how to proceed with and the representation of a lawyer as well. So we had an interesting discussion with regard to minor offences and the legal practice with Mr. Jagat Abenayaka, attorney at law. So thank you very much, sir,
Welcome.
for joining with us. And we had an interesting discussion, and our viewers might be able to grab many opportunities and many pieces of knowledge in order to strive in the field of law. So ladies and gentlemen, this is our program Law and Order. We have discussed minor offences today, and stay tuned for many other interesting topics with this program. Thank you very much for watching. Have a pleasant day.